May I seek your lordship's kind permission to mention a matter? It's a contempt petition. I am the petitioner in person in the matter. This is a misuse of a residential area for non-residential purpose. Your lordships were kind enough to issue notice in the matter on 5th of December to be listed on 9th of December. But till now, 7 times I have mentioned it and it has not come up. And it's 22nd it is shown, my lords.
We have passed a very detailed order. You have not seen it there.
This is not in that matter. This is a contempt petition because in the Delhi Citizenship, there is another matter where this honorable court has passed an order. This cannot be used for non-residential purposes.
There is no urgency in contempt.
Lordship is giving a date. 22nd it is shown, Lordship.
With my lord's kind permission, may I mention item 43 today, the Reliance gas migration matter my lords have been hearing. The Reliance gas migration matter my lords have been hearing. I have instructions that all the petitioners will be writing to the government to attempt a conciliation or mediation.
British Petroleum, we are also making a request.
We're making, Lordship will be writing to the government of India today, seeking conciliation or mediation. This is an ongoing contract. We're still in a relationship. We're submitting that let us attempt a mediation.
No,
conciliation.
It's only if the both sides agree. Otherwise, we will.
Your lordship will complete the hearing. Your lordship will complete the hearing. In the meanwhile, anything is happening, we'll come back and report to the court. Why should the hearing be?
And you can see, we can always grant you breathing time as far as best party. You conclude the argument. Because we will also take time after going through the report, and we will record that. Meanwhile, parties will mediate.
Now, my lord, pardon me.
Unless the parties will come to before us saying that mediation, if you come with a successful mediation, wonderful. We will dispose of the matter immediately. And unless if you say that yes, you are not been able to, then only we will think of proceeding on merits.
No, if some time is given, it will be. If some time is given to us.
Now let us continue on.
My lord, my
mention a fresh
my
matter, your
humble
lordship,
submission is that, my lord,
for
if the
listing before
address is
holidays, your lord,
altered,
this pertains
then
for
only conciliation will
free
be
committee
effective, my
report that was ordered by the
Both
Supreme
shouldn't
Court
run
and
parallelly.
directed MOEF to implement it, but 4 years have passed, MOEF has not implemented the report, and there is severe destruction of.
We will examine.
My lord,
I'll give the form.
Lordships.
my lord,
With your lordship said the matter may not be deleted. That's it. The motion.
We will examine it, whatever is.
Stand
Your
second
lordships, and in item number 4, my lords, the leave was granted and on the aspect of bail application notices were issued, my lords. Now, my lords, since the leave was granted, therefore mentioned, the matter was not listed after 2 weeks as originally granted, my lords. And that is why we have moved an early hearing application. The bail application is still pending in the.
Item 4.
Yes, my lords.
Bail application fixing a date.
With your lordship.
May I mention,
Fixing a date in the bail.
With your lordship kind
Yes, ma'am.
permission, my lord.
with respect, may I mention the Supertech matter? My lords had directed NCLAT to pass the order. That order has been passed, my lords. The matter was listed before my lords on 7th of May. Because of the constitution bench, my lords, it could not be heard.
Obviously,
So, my lords, before vacation, if we can be accommodated on any day.
we can't promise, we can only try, that's all.
Plus, may I mention,
My
plus the
lords, my
BCCI
lords, is
matter.
only for placing the NCLAT order on record.
Plus, may I mention the BCCI
My
matter,
lords,
which is coming up tomorrow, my lords.
Accommodated, my lords.
With your lordship's kind permission, my lord.
And the BCCI matter, my lords, 2 IAs which have been filed, my lords, that may be taken up tomorrow, my lords. It's already listed tomorrow before your lordship.
BCCI,
My lords,
Board of Cricket.
yes, my lords.
Yeah, what do you have? What is
So this is for the Bihar Cricket Association. There 2 IAs, one for direction has been filed, my lords. Already matters are listed, my lords.
My
My
lords,
lord,
speaking
like-
with
my
indulgence,
lord,
my
one
lords.
matter, my lord, which have been referred to the larger bench, my lord, regarding the interpretation of Article 20A with Article 30. My matter is also there, my lord, but it is simply tagged. I'm only requesting, please allow me to serve a copy to respondents, my lord. It will help, my lord.
You can always give copy. It is
My lord,
same matter.
at least, my lord, there should be some order, my lord.
Why does-
Please pass on this order. It was listed before.
You go to Justice Dipankar Datta, na, because there is an order by.
My lord, I mentioned there, but Honorable Justice Datta is sitting in 2 judges combination, my lord.
Today it will amount to reviewing lordship's order, that we cannot.
The lordships have said it, my lord. The order says, just please pass on, just see the order, my lord, please. Please.
Order says.
Order says, my lord, it should be placed before your lordships, my lord. Just see the order, my lord.
We file an IA, we will list before the same bench.
My lords, I'm
My lord,
sorry.
my lord,
My
because that,
Otherwise, you can always assist. We will hear you.
Only, my lord, just please, if lordships will allow me today to serve the copies, my lord, I will serve the copies.
You cannot pass that order, na, because you have to mention before the same.
This order says it has to come to your before lordship. Just see the order, my lord.
No, it will come before us. When it comes, then we will grant you permission.
It is in order, my lord.
No, but it is not listed today. We are not listing this week any matter.
One more thing, my lord.
When we list it, then you point out only.
One more thing, my lord. That freebies matter, my lord, with both parties are agreed on a committee, my lord. Your lordships needs only on the freebies case, my lord, freebies matter. Lordship needs only 20 minutes, my lord, to pass an order.
Remind in second week of July.
My lords, if I may.
My lord, with your lordship kind permission, I am mentioning, my lord, a request has been made by the learned advocate before the learned register. The immediate matter may be listed, my lord. We copy to my lord. My lord has directed the registry to list this matter because it is a case of Kakara Football Club. There is a misappropriation of the money, and now they are proceeding with the election with effect from 1st June, my lord. My lord has requested my lord has directed the registry to list the matter in the month of May. But let it be fixed on the next.
Election of what?
Pardon, my lord.
Election of what?
Election of the committees, my lord, against whom the allegation of fraud is there. That committee is presiding the election.
Society are you talking?
But I am only paid to participate in the election process.
I just want to know election of some society, election of parliament, election of assembly.
Kakara Football Club, my lord.
What is club?
But now the 1st June it will be commenced. My lord has directed. My lord, kindly peruse this order. My lord has directed to release the matter in the month of May.
We'll see after July.
But I am
Lordships, we were mentioning a leave granted matter. My lords, your lordships have been pleased to allow early hearing for November. The matter becomes infructuous in September. The appellant is a colonel in the Indian Army with 32 years of service. He's retiring in September. He has a disciplinary remark that's coming in the way of his promotion. I'm only praying for.
But also in service matter, nothing become infructuous.
Because it will be listed in the vacation. It's a very short matter.
Vacation, you bring the both sides. You go to the registrar.
Because I have informed, because the difficulty is that your lordship have a specific.
Please go to the registrar and give.
Because I've been to the register, if I may, Milos, the difficulty is that there's a specific direction from your lordship for listing on November. This is an early hearing application we had taken out.
We'll see.
Your lordships are directed to be
My lords, seeking your indulgence in the MC Mehta, my lords, the air quality matter, my lords had disposed of the matter by the judgment of 12th March. My lords, on behalf of the amicus, we are facing a small difficulty. My lords had directed all the AORs and parties in person to inform the registry by 15th May if their matter was infructuous. My lords, of the over 130 applications we've received information, I'm told by the registry only by 8. So my lords may direct the registry perhaps if a notice could be issued. Otherwise, my lords will not be in a position to assist, my lords.
On being mentioned, on oral mention, the matter is taken on the court. The open so is further clarified to the extent that if the advocate on the court so parties in person have not responded in terms of para so and so the order, from the registry directly to issue notice to all of them and seek their response in a time-bound manner.
Obligement.
Your Honor, may I mention a matter, Your Honor? On yesterday, my mentioning was allowed subject to curing or defect, Your Honor. The defect was marked at 4 p.m. and the dealing was given me only 15 minutes to cure the defect. It is demolition activities was.
Things I can't understand.
Your Honor, demolition was continued on 2nd, Your Honor.
At 8 p.m. you have filed the matter.
Yes, Your Honor.
And then you want us to list it today.
Your Honor,
What time it will go to the residence of the judge for reading?
Your Honor, at 4 p.m.
Don't
the defect was marked, Your Honor.
Tomorrow it will be listed.
Yes.
In the night you have given only.
Your Honor, at
No
4 p.m.
mistakes in processing time.
Your Honor, at 4 p.m. the defect was marked, Your Honor. After that,
What time you want the judges to read the file, please, sir? Give us 1 day time at least.
It's in the identical matters, so please to pass grant bail. I'm. I don't mind. Here's the matters of. The same order maybe. Same order may be passed. Yes.
My lord, item number 2, my lord. In fact, it ought to have been heard before Honorable Justice Pardiwala. He was not sitting today, that's why it's listed before your lordships. It can be listed sometime after the vacation, my lord, any date.
Item 2,
In mention. Item 2, my lord. Early-
it has been heard there, then we will wait for the decision.
Yeah, any date after vacation, my lord. And also liberty to file a small affidavit for the state. We have already filed a
We
detailed
are
one.
not aware of what is the matter and we will see.
Follow-up of
Would you like it?
follow-up of the
Judgment.
by Honorable Justice Parjiwal and Justice.
We will go there, my lord. We have filed a
Tomorrow.
small affidavit. We want to file one more affidavit. Kindly take it after
File
vacation.
supply supplement. No issue.
My lords, in item 5, there are 3 matters, my lords. Item 5 and 5.1 and 2, my lords. Maybe a similar order will be given to all.
All matters have been discussed.
Very good.
Same order.
I'm grateful, my lords.
Item 6, issue notice.
I accept notice on behalf of the state.
Accept notice.
Lord, may I pray for listing during partial court working days? This matter, my lord, item 6, may I pray for a returnable date during partial court working days?
During vacation, we can list.
Malaj, anytime, Malaj. We'll take about two weeks to file a reply, Malaj.
Post the counter affidavit you can file within 10 days. Within 1 week, post this matter on 1st June
Any day, Malaj.
Grateful, my
Any
lord.
day,
Great,
convenient.
great.
for the vacation bench.
Grateful.
Yes, item 7.
So this is Sudhakar Gumla.
Yes, tell Mr. Sudhakar.
Sir, I have filed a petition under Article 32
Ah.
of Constitution of India seeking to exclude caste enumeration as part of household surveys conducted through population census. As there are endless possibilities for misuse and exploitation of data by corporates, politicians, and also certain individuals. There is no justification for conducting surveys for collecting such large-scale data on caste. There is a plenty of.
These are all policy matters. We are not required to go into these things. Whether census should be caste-based or census should not be caste-based. These are all, what is wrong in asserting any day's government must know that how many people are backward class, how many people are, what are kind of welfare needs are required to be taken for them.
No, what I'm saying is there. What I'm saying is there is
policy domain.
No, there is already plenty of data is existing with the government itself, but they are not using them. But they are using. They want to go through these population census. So this also causes.
Now, caste-based survey, a census, being essentially a policy matter, we see no reason to entertain this resolution dismissal. Next. Sorry, sir.
My lord, petitioner is a former judicial officer, my lord, against whom disciplinary proceedings were initiated in the year 2001. And without conducting a proper and fair departmental inquiry in accordance with the statutory rules. Here the statutory rules is the Kerala CCA rules and Article 311 Clause 2 of the Constitution of India. My specific case is that, my lord, I was not given a reasonable opportunity to defend the charges or a reasonable opportunity to establish my innocence. The High Court has, by impugned judgment, without considering any of the merits of the contentions, paragraph 7 to 12, if your lordship go through, there is no discussion as to the merits. My first point was that, my lord, the copy of the complaint on the strength of which the preliminary inquiry commenced against me was not given to me in spite of my specific request submitted before the inquiry officer. Lordship finds that if the copy of the complaint is not given, the employee is prejudiced in 3 manners. First of all, he is denied the right to know what is the exact case against him. Secondly, the paramount right of cross-examination of the prosecution witnesses is denied. Thirdly, if he wants to submit any explanation, any objection, or any representation, and this was settled by a constitution bench decision of the apex court, this court, in state of Madhya Pradesh versus Chindavan Sadashiva Vaishambhayan, may I submit, my lord, this is a unanimous decision of this court, where this court categorically held that if the copy of the complaint is not given, dismissal order has to be quashed. That is paragraph.
What are you giving to us? Huh?
What?
We are aware of these judgments. It's not that first time you are saying it.
My lord, I am just referring to the, in order to.
Has been followed meticulously.
No, my lord, my specific case is that statutory rules are not followed. This is a violation of Rule 15, Clause 2A and
PW 22 has been brought into witness box. He has explained everything of how the
that
took place.
I have specifically stated that it is a case of no evidence, my lord.
Demand of bribery
That
and
is
everything.
that is only one aspect. The other aspects regarding principles of natural justice, my lord, your lordship finds that Article 235.
Inquiry has been held, you have been given.
No, Article 235.
Inquiry report has been supplied, show cause notice was given.
Lordship finds
Reply has been considered.
at least my contentions may be considered, my lord. He is a person with a permanent visual disability, my lord. I have produced the disability certificate also. My contentions are not considered, at least the violation of the statutory rules, violation of the constitutional provisions, argued before the High Court.
We see no ground to interfere in the implementation.
My lord, your lordship may kindly see that this is a case where my contentions are not considered by the High Court, my lord. At least a remand may be given, my lord.
Thank you very much. Thank you.
My lord, already around 3 or 4 contentions I have raised regarding paragraph 7 to 12, regarding violation of natural justice, my lord.
All right, thank you very much. Thank you. We have heard you and we have seen.
235, my lord, is subject to the statutory rules, my lord.
Yes, yes.
Without complying with the statutory rules and the principle Article 311 Clause 2, a reasonable opportunity, my lord. It is said, my lord, as per the Holy Bible, my lord, it is said, even God Almighty did not impose a punishment upon Adam and Eve without affording a.
We have heard, sir, we find no ground to interfere.
My lord.
Thank you very much. Thank you.
Contentions are not considered, my lord. My submission.
Yes, Mr. Chandra.
Please, a remand may be given to consider the.
We have considered it and we do not find any ground. Understand it now. Yes, Mr. Chandra.
सम्मानित आदरणीय जज साहब, आपके सामने चरणजीत सिंह मैं जनहित याचिका लेकर आया हूं, जिसका आधार भारत की शिक्षा है। श्रीमान जी, सर, जो भारत की शिक्षा है, जब तक ये सही नहीं होगी तब तक आप जैसे महान जो यहाँ पर आप बैठे हैं, जो न्याय दे रहे हैं पूरे भारत को, वो सुनिश्चित नहीं हो पाएगा सर। उसके लिए मैंने ये जनहित याचिका डाली है सर। इसमें जितने भी पार्टीज को मैंने निवेदन किया है आपसे, उनको नोटिस देके हम उनसे इस शिक्षा नीति को, भारत को विश्वगुरु बनाने के लिए, सर्वोच्च स्थान दिलाने के लिए, शिक्षा नीति के लिए काम करना चाहते हैं। इसमें मेरा कोई भी किसी भी प्रकार का हित नहीं है श्रीमान जी।
जी, आपने सर्वधर्म
जी सर,
जी सर, जी सर, आपकी बात मानते हैं उसमें।
जी सर,
पर उसमें हमें चंद्रशेखर ये लगता है कि एक बार पहले आपको जितना भी आपने इतना मेहनत किया है, उसमें रिसर्च भी किया है,
जी सर,
और बड़ी अच्छी विद्वता के साथ आपने सारी बातें निकाली हैं, तो इसको एक बार सरकार को या जो भी अथॉरिटीज हैं।
सर, मैं कर चुका हूं सरकार को, और इंटरनेशनल कोर्ट में भी सर इसको मैंने डाला हुआ है, और सर मैं अनेक बारी शिकायतें राष्ट्रपति साहब को, प्रधानमंत्री कार्यालय को लिखित में भी दे चुका हूं सर, लेकिन उन्होंने इस पर कोई कार्रवाई नहीं करी है सर। जो सर विरासतें हैं ना सर, जो सर हमारी आने वाली पीढ़ियां हैं, आपकी हमारी सबकी जो आने वाली पीढ़ियां हैं, उनको यदि उनकी अधिकार की शिक्षा प्राप्त नहीं होगी श्रीमान जी, तो तब तक शिक्षा नहीं होने की वजह से हम बहुत पीछे रह जाएंगे। जैसे हमारा देश इस समय 1.4%, 1.4% पैसा शिक्षा नीति पर खर्च कर रहा है श्रीमान जी। आप देखिए, चीन अगर हमसे 100 साल आगे निकल गया है तो वो 5 से 7%।
आप ये बताइए, अधिकार तो आप उनको बताएंगे, कर्तव्य नहीं बताएंगे क्या?
सर, हम उन्नत शिक्षा नीति जो है, देखिए धार्मिक जितने भी केंद्र हैं सर सभी धर्मों के, वो सभी धर्मों के केंद्रों के पास सर बहुत पैसा आता है, लेकिन वो पैसा अन्य कार्यों में खर्च हो जाता है, यहाँ तक कि राजनीति में भी सर खर्च हो जाता है, लेकिन वो शिक्षा पर खर्च नहीं कर रहे हैं सर।
ऐसी बात नहीं है, सारे कुछ तो अच्छी संस्थाएं चला रखी हैं।
जी जी।
आप देखिए, आप जितने भी अपने गुरुद्वारा प्रबंधक कमेटी हैं, कितने अच्छे अच्छे आप कहाँ से बिलोंग करते हैं?
सर मैं दिल्ली से हूँ, और दिल्ली सिख गुरुद्वारा मैनेजमेंट कमेटी नहीं सर, अभी मैं आपको बताना चाहता हूँ सर।
अगर पंजाब में जाओगे आप,
जी जी जी,
रूरल एरिया में, कुछ गांव में, छोटे कस्बों में, जो हमारे लोकल वहाँ पे श्री गुरुद्वारा साहिब की जो प्रबंधक कमेटी है,
जी सर, जी सर,
उन्होंने बहुत अच्छे अच्छे स्कूल चला रखे हैं।
जी सर,
आप देखोगे उनको सरकारी स्कूल से अगर तुलना करोगे तो वो स्कूल बहुत अच्छे हैं।
जी सर,
शिक्षा के उसके भी वहाँ पे जो मोरल एजुकेशन है,
जी सर, जी सर,
क्वालिटी ऑफ एजुकेशन के एंगल से भी जो बच्चों को फैसिलिटीज का देखेंगे वो भी अच्छा है।
जी सर,
मेडिकल कॉलेजेस भी हैं, कॉलेजेस भी हैं, ऐसे बात नहीं है
सर हैं, लेकिन उसमें सर काफी त्रुटियां आ गई हैं। अभी दिल्ली से गुरुद्वारा मैनेजमेंट कमेटी का हाई कोर्ट में केस चल रहा है सर, हमने उसमें इम्प्लीड होने की कोशिश करी, कुछ जायदादों को वहां पर सर वैल्यूएट कर दिया गया। वैल्यूएट का मतलब होता है सर, अगर एक बारी वो वैल्यूएट हो गई तो दोबारा सर वो वापस नहीं मिल पाएंगी। इस तरह के सर बहुत सारे केस पूरे भारत में चल रहे हैं सर।
आपने जो भी विषय इसमें डाला है ना,
जी सर,
उसमें कई सारे ऐसे एक्ट हैं जो कोई पार्लियामेंट का एक्ट है, कोई स्टेट का एक्ट है,
जी सर,
अमेंडमेंट करना पड़ेगा।
जी सर, जी सर,
ठीक है, वो अमेंडमेंट की पावर हमारे पास नहीं है।
जी सर,
हम कोई अमेंडमेंट में कोई नया कानून बना या उसमें कोई अमेंडमेंट हुआ, वो अमेंडमेंट या वो कानून संविधान के अनुसार है कि नहीं, ये तो हम चीज एग्जामिन कर सकते हैं।
जी सर, जी सर,
लेकिन नया कानून बनाने का अधिकार हमारे पास कुछ पावर है, वो 142 की वो एक अलग किस्म की पावर है। हम सीधा ये नहीं कह सकते कि ये कानून बनाया जाए, ये हमने ड्राफ्ट कर दिया और आप इसको कानून
सर,
वो जो जनता के प्रतिनिधित्व है जो करते हैं, ये उनका काम है। इसमें आपको एक हम तरीका बताते हैं। एक पार्लियामेंट में एक कमेटी बनी हुई है।
जी सर,
उस कमेटी का नाम ही पिटीशन कमेटी है।
जी सर,
और उसका काम क्या है, उस कमेटी की बड़ी जिम्मेवारी है उसको लोग समझ नहीं पा रहे, लोग उसका फायदा नहीं उठा रहे। उस पिटीशन कमेटी की जिम्मेवारी ये है कि भारत का कोई भी नागरिक कोई कानून में कोई बदलाव चाहता है या कोई नया कानून बनवाना चाहता है,
जी सर, जी सर,
वो वहां पे एक पिटीशन डालेंगे और उस कमेटी की फिर जिम्मेवारी है वो उसको एग्जामिन करके और फिर आगे जहां भी पार्लियामेंट में जो भी उनका अपना प्रोसीजर है उसके हिसाब से उसको आगे रखेंगे। तो आपसे हमारा निवेदन ये है कि जिन जिन कानूनों में जिस बदलाव की और एक नई व्यवस्था की आवश्यकता आप हमें बता रहे हैं, ये सारी बात हम लिखेंगे आपके लिए उसमें।
जी सर,
आप वहां पे एक पिटीशन फाइल कीजिए, हम उस पिटीशन कमेटी को बोलेंगे कि आपके इन सारे इश्यूज को एक बार एग्जामिन।
सर एक रिक्वेस्ट है सर, आर्टिकल 32 के तहत जो संविधान की आत्मा है सर, बाबा साहब अम्बेडकर साहब ने कहा है जब तक संविधान को सर मानने वाले और मनाने वाले सर पूरी तरह सही नहीं होंगे, सर एक निवेदन स्वीकार कर लीजिए सर, एक रिक्वेस्ट है सर। सर बड़ी मुश्किल से यहाँ पर आया हूँ, 60 साल लग गए सर मेरे को यहाँ तक आने में सर,
यहाँ तक आने में आपको कैसा लगता
सर 60 साल लग गए हैं सर। आपसे निवेदन है, ये मत्थे टेकते हुए आपसे निवेदन है सर।
दिल्ली में रहते हैं?
जी सर, दिल्ली में रहता हूँ।
दिल्ली से यहाँ तक आने में कैसे 60 साल लगेंगे आप?
सर इसलिए 60 साल लग गए।
हम आपको इसी स्क्रीन पर घर से बैठ करके सुनेंगे, आपको यहाँ भी आने की जरूरत नहीं पड़ेगी।
सर रिक्वेस्ट ये है कि सर ये जो गुरुद्वारों कमेटियों में ना सर, इस समय माफी चाहता हूँ सर, मैं अपने लिए ही बोल रहा हूँ, जो लालच आ गया ना सर, निज हित आ गया सर। हम लोग हुआ करते थे सर, अपनी जान दे देते थे संगत के लिए, दुनिया के लिए, समाज के लिए, गलतियां आ गई हैं सर, उसको रोकने के लिए निवेदन है सर। एक बारी सर अगर नोटिस करने की कृपा कर दें तो बड़ी मेहरबानी होगी सर।
हो सकता है थोड़ी बहुत आपकी बात ठीक हो, लेकिन ये बड़ा कोर्ट के लिए ये बड़े सेंसिटिव मुद्दे होते हैं। हम किसी भी धर्म की व्यवस्था में, आपका गुरुद्वारा प्रबंधक कमेटी एक्ट बना हुआ है 1925 का,
सर उल्लंघन कर रहे हैं पूरा।
1925 का एक्ट है,
72 का सर।
25 के एक्ट में आपको ये भी पता होगा, एक व्यवस्था है कि अगर किसी गुरुद्वारा की संपत्ति को लेकर के, उसकी आय को लेकर के अगर कोई किसी किस्म का कोई मान लीजिए उसका मिस अप्रोप्रिएशन हो रहा है या उसका दुरुपयोग हो रहा है, तो एक आपको पता है सिख गुरुद्वारा ट्रिब्यूनल भी है।
जी सर।
तो ट्रिब्यूनल जो है वो हाई कोर्ट का सिटिंग जज प्रिजाइड करता है उसको, उसमें साथ में कुछ हमारे सिख धर्म के कुछ विद्वान लोग भी बैठते हैं।
जी सर।
तो वो एक हाई कोर्ट के जज उसको प्रिजाइड करते हैं। तो आप अगर ऐसी कोई बात है तो उस ट्रिब्यूनल में जाइए।
सर अनेक कमेटियां पहले ही बन चुकी हैं सर। मेरा
कमेटी नहीं है, हाई कोर्ट के जज का ट्रिब्यूनल है।
सर अभी हाई कोर्ट में 2 केस चल रहे हैं सर, 160 केस हैं उसमें ज्वाइंट किए हुए सर, 160 केस।
आप पंजाब हरियाणा हाई कोर्ट में जाना पड़ेगा उसके लिए आप।
सर हम वहां पर गए थे, उन्होंने कंप्लीट तो हमें कर लिया, लेकिन जब हमने कहा कि आपने ये जो वैल्यूएट करा दिया, जमीनें वैल्यूएट हो गई हैं सर, अगर वैल्यूएट हो गई हैं तो सर उसको वो बिकवा भी सकते हैं, इसलिए सर
ये धार्मिक उसमें कोर्ट का दखलंदाजी मानी जाएगी। ये हमारे को थोड़ी सी इस व्यवस्था में हमें परेशानी रहती है। हमने अभी के मुकदमा सुना है लंबा चौड़ा, उसमें हम देखेंगे क्या क्या।
सर मैं आपसे माथा टेकते हुए हाथ जोड़ के निवेदन करता हूँ, एक बार ही अगर सर नोटिस कर देंगे तो बड़ी मेहरबानी होगी।
पिटीशन कमेटी में जाइए, जहाँ भेज रहे हैं वो एक बहुत अच्छा, उसके आपके लिए एक बहुत अच्छा प्लेटफॉर्म है, उसमें जाइए, वहाँ पे अपनी बात को रखिएगा और हमें पूरा विश्वास है वहाँ आपकी सुनवाई होगी।
सर मैं आपकी आज्ञा को सिरधार्य करते हुए जैसा आपने आदेश दिया है, मैं उस कमेटी में जाने की कोशिश करता हूं। आपके निवेदन, सॉरी मेरा निवेदन है सर,
इसमें आपकी सहायता कर रहे हैं, हम ऑर्डर में लिखेंगे ये बात
जी,
कि आप वहाँ पे आएंगे और आपकी बात की सुनवाई होगी।
सर मैं आपकी आदेश को सिरोधार्य करते हुए, आपका पूर्ण सम्मान करते हुए आपसे इतना ही निवेदन करना चाहूंगा, यदि वहां पर कुछ ऐसा ना हुआ तो पुनः मैं आपके सामने हाजिर हो सकूं, इसका मुझे
हमारे दरवाजे हमेशा खुले हैं, ऐसा कोई नहीं, ऐसा नहीं है कि वो आप नहीं आ सकते।
बहुत बहुत धन्यवाद सर, बहुत बहुत मेहरबानी, पूर्ण सम्मान के साथ। कोई भी गलती हो गई हो सर क्षमा चाहता हूँ।
कुछ नहीं, आप आइए, आपका सभी का सम्मान है यहाँ पे। आप
ये सभी के लिए सर, पूरे समाज के जो विरासतें हैं सर, बहुत सारी विरासतें सर।
आप हमारे लिए देश के बड़े सम्मानित नागरिक हैं, आपके लिए है ये सारी व्यवस्था, आपके लिए बनी है, किसी और के लिए नहीं बनी। आप जब भी आए तो आपका हमेशा हमारे लिए कोई समस्या नहीं है, आप जब मर्जी आना चाहिए।
सर आपका बहुत बहुत धन्यवाद, कृपा करके सर वो आदेश मेरे को दे दीजिएगा। मैं कब तक ले सकता हूँ सर?
आप जब मर्जी जाइएगा, हम आपको आप 10 दिन में जाएं, 15 दिन में आराम से पिटीशन को बना लेना उसके हिसाब से, फिर आप जाइएगा।
धन्यवाद सर।
Your Lordship, this is a land acquisition matter where Lordship has already passed a common order for a similar. Yes, Your Lordship can pass a similar order. Your Lordship, I'm carrying a compilation of those orders.
Just a minute. Have we issued notice or first time?
No, it's coming up for the first time, Your Lordship.
Comes a delay also. We issue notice, notice recommendation delay also. Returnable also.
May please, Your Lordship.
Yes, Mr. Bhatt.
For super time scale, my lord, my case was rejected, Lord, wrongly in my humble submission, Lord, for 2 reasons, my lord. First and foremost, my lord, judgments were called for. My lord, the norms do not prescribe. In my humble submission, norms don't, because
that is closed.
Pardon me?
That portion is closed after the Supreme Court dismissed that petition.
No, my lord.
Challenge.
Your lordships have, my lord, allowed me to go back.
We've seen that order also.
Lord, your lordships have allowed me to go back.
It's in the order.
Yeah.
That you can re-agitate. But
That's right.
re-agitation must be on new facts.
No, my lord, that your lordships have done, sir. My my lord, I sought clarification from your lordships, my lord, at that time, saying that rejection of super time scale was not argued at all, because at that time, my lord, I had filed writ petition on two grounds. One is, my lord, the supersession, my case was not considered for my lord, elevation. That was one ground.
No, prayer C was there.
Yes.
Prayer C in your writ petition.
Yeah, before your lordships.
You know, in the first writ petition, prayer C,
Yes.
which is quoted by the High Court,
Yes.
speaks of a challenge to the super time scale.
That's fine, that's fine.
Because your elevation question of your not being considered for elevation actually stems from your not being granted the super time scale.
That's right.
So it becomes intrinsically entwined.
In the sense, I bowed
Now,
down to that.
MA,
Yeah.
and that is perhaps the most important point you have, that does the MA order
Yeah.
really reopen the entire issue?
Miller Rohigyas turned to the MA and the
Yes,
other past.
come to page 367.
Yeah,
We can
367.
We can accept your contention only, we can accept your contention only if we hold that that order virtually amount to setting aside the High Court judgment and remanding the case back to High Court. So what you could administratively agitate.
I was granted, my lord, time scale. Super time scale is concerned, my lord, I have not been rejected. But 2013, my lord, judgments have been called for. Lord,
But only a question of monetary benefit to your club.
no, I am working, still working.
You're still working.
Yes, yes, I am going to retire in the year
29.
2032.
32.
32 or 33, my lord. I still have time. Because my juniors have, my lord, now taken a march over me, my lord. They have become High Court judges. I have been, my lord, 2008 batch. Well, my lord, so that this returnable date, my lord, so that
That future consideration can be done independently.
that's it.
I'm seeking a short pass over my heads.
We have already issued notice in a similar matter, right? Issue notice returnable on Swansudu. Tag with the petition civil number 259/2026. At least you should know that similar matter we have issued notice. I am hopefully seeking pass it.
My lord, as per the Home Guards Act, my lord, section 13, my lord, Home Guards can be removed on the reason that he disobey or fail to discharge duty, my lord. On calling, he failed to join the duty, my lord. But in the instant case, Home Guards have been removed only because they are member of a welfare association. And thus holding that the being member of a welfare association, the Home Guards have violated Police Forces Restrictions of Right Act, my lord. Admittedly, my lord, this act is not applicable.
Argument that it is debatable whether you are covered by the Police Act, but you were a public servant.
My lord.
As a public servant, if you are becoming a member of an association, you have a duty to intimate or take permission of the.
Be informed, my lord.
No, you informed after you had become a member.
Because about-
And that is when 1911, 19 circular comes.
My lord, Association of 6,000 states formed in 31st December 19, my lord. On Tamil Nadu state unit formed in March 2020, my lord, during Corona, my lord.
Sir, when 31st December South India Association is formed,
My lord, not,
your
this is Southern state, my lord. Tamil
That is
Nadu
what
state.
southern state, whatever your association is formed, there is already a circular given by the government of Andhra Pradesh saying that you should not be a member. That is 1911-2019 circular. Now, in spite of that, if you become a member, forget about membership of the police association. You are not acting in a disciplined manner. That is breach of Rule 7. Look at it from that angle. We understand your Article 19 rights. But Article 19 rights also must be exercised in a regulated manner.
During Corona,
Avail 19, or go avail 19, and don't go for the.
March 2020, during Corona, my lord, state unit petitioner association was formed, my lord. Thereafter, we informed them on September, my lord. We informed them, and the state representation is still pending. They have neither decided nor rejected, my lord. Our representation, my lord, our representation, they have.
For the High Court, now some union has come. From where this association has
They have been removed, my lord. Problem is this, man, during Corona, my lord, they were paid to 5,000 per month, my lord. And that was also not regular, my lord. That is why some of the members gave a representation to the SP. And this is counterblast to their representation, my lord, because they were not getting regular salary, my lord. For 3-4 months, they were not getting salary during Corona. That is why, my lord. But our representation has not been decided till date, my lord. It is kept pending. My same association has filed earlier petition before which is pending, my lord. And that is respect of this, they have reduced our call out, my lord. Earlier, in order to implement the Honorable Supreme Court's order that the home guards are entitled for the same allowance as the constables, what they did, my lord, they enhanced our duty call allowance, but reduced the day, my lord. So effectively, whatever we were getting earlier, my lord, we are getting reduced rate, my lord. And that is why, my lord, this reparation was done, my lord. And within time, we inform, my lord. As as the condition became normal, my lord, we gave representation and sought permission to approve our association, my lord.
Or at least home guards are expected to, you are kind of a substitute of sometimes police personnel in terms of maintaining land order and.
Where we do traffic work.
Traffic work in any public nuisance or anything, you take care of that. Sometimes on the public streets, roads, children are there, women are passing. So you people, when are there, it's a sense of security you bring to them. So you are in a way treated as part of a kind of para police force. You are indulging in union bazi. What can be done?
In this case, my lord, this police is certain also allow formation of association for welfare work, my lord. For welfare, even police force can
Those
be
instances are not before us. Now it is some union through this petition.
as per section 4, my lord, as section 4 of the Incitement to Dissatisfaction Act.
No, we will not
allows formation of association for welfare purpose, my lord.
Say, remove the fact that the petitioner, just a so-called association, was not party before the High Court. We find no law personalizing the petition to approve this statement.
But at least removal should be some reasonable and fair cause, my lord. Only because removal should be some reasonable and fair cause, my lord. Only because a person is member of association, my lord. It is very unfair, unjustified to remove the persons, my lord.
Voluntary association.
But in the light of, because even IS and IPS are having association, my lord. Even higher officers are association, my lord, and the persons who are at the front level, my lord, they are the right to form association, and even for the welfare purpose. And this is only in that particular state, my lord. Is other all other states, my lord, there is welfare association.
When the individual will come, we can still think of what kind of benefit to you. But some association coming, they are not before us, those who are before petitioners. We can't entertain SLP at the instance of strangers. Item 15.
Lords, I request for a pass over, Lords, in item 15. Lords, you will let
We go on some other date. We have to start part in it.
Please, Lords, any date
Okay,
meeting,
like-
Lords.
Item
Look, 16, after the filing of the writ, I'm conscious Lordship passed on UP order. But could my Lord just see page 16 to 18, how the excise regime is played out in this country, where the definition of bottle is so vague that Lordship may just see one page, page 18, the Andhra Pradesh Excise Act. The problem is here, the definition of bottle is so varied, it includes even a sack, a wrapper. So some standardization has to come, my Lord. That's as far as the excise regime is concerned. Lordship may just see Andhra. And my Lords, could my Lord see page 91? Page 91, could my Lord see 91? That's page 91. Oblige.
Agreed SLP, civil diary number 294.
And there's no warning sign also. Unlike tobacco, 80% of the cigarette pack should be a danger sign. In this page 91,
That, of course, they will mention 40%, 43, whatever it
but
is.
it's fine print.
So problem is that this packing.
And Lords, not just that, Lordship may just see page 91. The dangerous part is they are confusing the fruit juices with the liquor. They put Apple's photograph and then they put vodka under that. Right?
He cannot advertise for liquor.
That's true. Surrogate advertising,
Surrogate
this is direct, Lords. So state has a duty to promote health. And it's under the state list, my Lord. That's the difficulty. Page 91, Lordship may see page
Green apple.
page 93.
Green apple vodka,
Chili, my Lord,
7.5%.
well, 93 is chili mango vodka, my Lord. What more? It's absolutely brazen. Lord,
Very deceptive.
notice to all. Yes.
This petition, Lord, is based on the survey that the SCBA had done, where Lord, but there is a bigger challenge which actually is not reflected. I'll not amend that prayer today itself, that even when you are actually given the panel, work is not given, which I'll just change to during the course of the day only. In fact, Monica is here, she tells me that in Haryana, 3,000 matters are allocated, only 80 went to lady lawyers. So even if you are there in the panel, work doesn't come. So it will have to be included in the panel and given sufficient, that's by the same percentage.
Let's find out, Dr. Monica, that how many women of law officers are there in the AG offices throughout on pan-India basis?
A lot.
Because nomenclature are different. Like in Punjab and Haryana, you will find so many additional advocate generals, senior deputy advocate general, deputy advocate general.
Not in Haryana, senior additional advocate general, so far not a single lady has been appointed as senior double AG. Ever since a post has been created.
No, as senior additional advocate.
Senior double AG.
No, additional advocate general, their ladies are there.
General, they are there. They are getting a monthly stipend also, but at times not a single case is marked for the whole month.
But why
So
to,
that money is
why
going
to talk of senior additional AG? No, advocate general has not been appointed. Now, why? Because senior additional AG is only one step above the additional AG.
and one step below the Advocate General.
I didn't agree to creation of this kind of nomenclature. I had only additional advocate general and that too limited one. I still recollect. But at that time the work pressure may not be as much as now. The courts have increased, the work has manifold.
Fortunately, in our national conference, Justice Nagaratna spoke, and then just the Attorney General also said that it should be 50%. In fact, he agreed readily.
Is there any woman advocate general?
Women Advocate General.
I think there have been one or two.
One or two in the entire country so far. Only one or two. Because we can only rely on Google information from various aspects.
It is only when the states come and tell your lordship that
Yes.
your lordship will get a.
That is why we need to implement the Bar Council of India as well as Bar Association of India as well as all the high courts also.
This is, I think, good enough. The states
It's
should be.
required, my lord, because during the session also my lord had made an observation that Bar Council of India wasn't there. We need to implement the Bar Council of India also.
Not in this
I made a
petition.
prayer.
Bar Council, my friend, she's wanting we should file as SCBA should also file separately. We can do that. But in this, not according to me, the states, because the panel is being given only by the state, nothing to do with the Bar Council.
But we
Panel is entirely done by the state government.
then there are so many other difficulties being faced by lady advocates. So that is why the PIL has to be through the SCBA also.
No, we'll do that also. In fact, we'll file another bench so that both can be heard, because there will be some prayers there which may not be here. And give me liberty to amend the prayer today itself, Lord. I'll file the amended prayer today.
Or bring some comprehensive material on the code. You can also help.
Yes.
We not can have the matters next week.
And for liberty to amend the prayer.
Yesterday, Telangana Bar Association office bearers met me.
My lord.
And of course, as usual, a young joint secretary has been elected. So she told me, my lord, that I'm thankful to you that because of your orders that I'm there, that the young children will say like this, no difficulty. But then I inquired from them that how many women lawyers are there. So I was pleasantly surprised that the total strength of the bar is 19,000. 8,000 are those who regularly come there, and out of 8,000, almost 2,000 are the women lawyers. So again, this problem is there that only one office bearer first time, and in AG offices, and again there is.
Even in law colleges, there is a welcome change. So today, somebody come to me. They said in their college, more than 50% are girls.
The entry point, Mr. Singh,
Mostly
is
more than
very,
50%.
very rosy at the
70%.
entry level. But the attrition rate of
So
women lawyers are much
coming in
more.
litigation is actually a barrier. Somehow,
If you see the entry point,
if this panel happens and work, then this will improve automatically. Because if they are,
point is very gender positive.
your lordship's right. That is where.
Once you see the tenure for which they are associating with the profession, there is a continuous attrition with 5 years, 10 years. So
That is why this will help,
panel-
Lord. Ultimately, this will be very beneficial. So, Lord, only one liberty to amend the prayer. That if your lordship will just put that. Now, Sing, Lord.
Litigation only to the appointments. Because this issue itself is a very problematic.
I agree, Lord. But ultimately, what is happening, if you see the matters not being allocated, and today there is a very welcome change, Lord. Now, this virtual hybrid being available at all points of time, the woman advocate, when she goes for childbirth, etc., she can still participate from her residence, which was not available earlier. So, if you make them in a panel advocate, they can probably be of
Because perform both duties very.
more from home also. Yes. Crash we have, like Supreme Court has a crash, but a lot of the High Court have.
This question is half I think at the district level, there is no
There is
awareness or nothing.
no district level, there are not even proper toilets for women. That's
I set up a crèche, one of the most beautiful crèche, and there were so many women lawyers, children will come with them, and they used to be.
creche fortunately was inaugurated in my first tenure, and the Supreme Court creche, and that is functioning very well. Women lawyers are going there.
I think most of the high courts are. Based upon your survey, the other issue, let us confine this matter because
This is only for
a
panel.
very big challenge.
This is for panel.
If you partly succeed in this, I think that it will be a
At least
great.
it will be a big victory. Very well. Did some returnable dates for that not needed. Deeply obliged.
Item 18.
Yes. Manoj, I appear for the transfer petitioner. I'm seeking that the writ petition, my writ petition pending before the Bombay High Court, Nagpur bench, be transferred to this honorable court. Identical issues are pending, my lords, in the writ petition 180 of 2004, where a challenge to that SRO of 19.
Pending.
No, it's been pending for 26 honorable court's orders, so that I may get an audience when my rights are adjudicated upon before this.
Everything notice you are present. I decide this case, at least we will have advantage of a judgment.
My lords, the judgment will just follow the Bombay High Court's division bench, which has earlier ruled upon this, and that very order is the leading matter in that batch matter that is pending before this court.
Can you wait for this batch matter to be disposed of here?
Then, my lords, I may be given a chance to represent myself.
No, I think your information is not correct, man. What is pending before this court is a writ petition, not an SLP.
My lords, the various SLPs have also been tagged with that, and the leading matter is an SLP converted to a civil appeal where leave is granted. It is challenging an impugned order of the Bombay High Court itself.
Then you should become party to the proceeding, pending proceeding. There is no need for you to get that matter transferred from here.
Then, my lords, may give me liberty to file a writ petition before this court in
Not require any liberty if you withdraw your pending proceeding from there with liberty to file a writ petition here.
But my lords, if it could just be transferred, I'm an old.
Why to file a separate writ petition? You can become party to the pending proceedings.
No, my lords, actually the writ petition pending before the Bombay High Court, I am challenging a termination based on this interpretation of this SRO. I was terminated because they said I wrongfully.
You are presuming that High Court will follow that judgment. If somebody may take a different view also.
My lords, I can show successive orders for the past 26 years where they will not.
Request the High Court to decide the matter. Let us see, even if suppose they follow, we agree with you. What will happen? You will file SLP. Like other SLP.
Finality would still not be achieved because.
Your matter will be decided. At least you want to come here. You will come here through proper channel.
Lords, he is an old person. Even I am doing this pro bono. If I could just file additional grounds before this court and the matter could be transferred.
We will examine the order passed in your judgment. There may be other reasons why the termination may be upheld.
Conflicting views of various high courts as well, and the twin conditions for Article 139A for the transfer have been satisfied by this court's judgment in this petition itself. If my lords could just come for just my satisfaction, my lords.
For the instant transfer petition seeks transfer of with petition number 532/99 titled so and so pending before the Bombay High Court in the Nagpur bench to this court. However, we do not find any legal necessity to entertain such a prayer. The grievance of the petition can be effectively addressed by requesting the High Court in the Nagpur bench to take up a petition number 532/99 on priority basis and make an endeavor to decide the same within 4 months. It is clarified that you have not expressed any opinion on this.
Obliged.
My lord, a blatant violation of the directions of this court. No demolition can take place without the directions. May I just pass on the judgment of this court?
Pass over in that. What is so?
No, what they do is they enter into a scene. The government policy is
The property which is being demolished has already been purchased by the state by paying consideration through a registered sale deed executed by your brother. You are claiming that you have not been given share.
In fact,
property dispute between you and your brother.
it's not a question of property dispute, my lord.
Yes.
In fact, the counter affidavit, if my lords will kindly look at page 132.
And that's why you have rightly filed a writ petition in the High Court, which is pending, claiming compensation. Because you are saying that you are a co-owner, your sister is co-owner, and you both were also entitled to compensation.
Please, my lord.
Maybe your claim is justified. That matter is pending before the High Court. Today you say why it is being demolished. It demolished because the state has paid the entire compensation to your brother. Might be your brother has cleverly, dishonestly, inadvertently, or maybe that whatever may be reason, those reasons will be examined by the court. He has taken the entire compensation. Property is no longer a private property. It is the state property.
The counter affidavit.
Stand of the state.
No, what the government states in the counter affidavit is you were not available. Therefore, we entered into a sale deed, fully aware. I have a stake in that property. Fully aware.
You have a very good case to the extent of the transfer of your right in the property in favor of the state, where the deed is executed by the co-owners. But with regard to the violation, it does not become an admitted fact by the state that they had violated. If you see the counter, rightly or wrongly, they say that we entered into the sale deed with the co-owners, and the co-owners themselves demolished the property. Now, be that as it may, you already have a writ petition. You've paid for compensation, you paid for cancellation to the extent the land belongs to you. You can easily amend and say that consequentially, if there is a demolition demonstrated by the state agencies, that appropriate steps be taken against them in accordance with law. Why a separate?
And
that is exactly
highlight
what
to
has been given also.
Yes, my lord. What I wanted to highlight, my lord, what my lords passed in that judgment of writ petition of 265
That's a
was
slight.
to avoid these kind of situations.
That's
a small notice
that
at the side.
That is a slightly different fact situation from the one that is transpiring here. Here is a case of a few co-owners handing over the land through a registered instrument where others have not joined in, and thereafter the demolition process has begun. Debatable whether the demolition was by the state or by the co-owners themselves. In the case that you are referring to is a brazen state action in continuing with demolition on a perception of illegal construction, and that too with a collateral motive. This is not a situation which fits.
I would have, my lord, I would fully agree with my lords, my lord. The difficulty arises, they are fully aware I have a stake in the property. At page 132 in the counter affidavit.
You should immediately concentrate in getting decided your petition pending. Yes. Because that will determine, one, you have a... That's the best.
No, that's it. Yes, my lord, subject to my lords. If my lords will make an observation that that petition may be expeditiously heard, my lord, I will be much obliged.
This is 1365.
Yes.
Your writ petition.
My writ petition in the High Court is 1365.
We have heard and seen a counsel for the petition. We see no ground to interpret the order dated 3rd February 2026 passed by the High Court. The appropriate remedy, the appropriate and effective remedy for the petitioner is to seek out of turn, to seek early stroke out of turn disposal of writ-C number 1365/2025, which is still pending, filed by him, which is still pending before the High Court. While dismissing the special petition, formal liberty granted to the petitioner to seek prioritized hearing in the government case.
Much obliged. For the your lordship.
My difficulty is, Your Lordship, my matter is not taken up for hearing, Your Lordship. My early hearing application is not listed. We have filed the copy of the evidence and the learned advocate will pass the bar by 31st of July. So I will be in difficulty. My petition before the High Court will enter in factors, Your Lordship.
Better before the High Court.
I had filed an early hearing application. That too was not listed for hearing, Your Lordship. The difficulty is this, we have filed.
You see no ground to entertain the petition under Article 52 of the Constitution. The petitioner, however, shall be at liberty to pursue the pending petition before the High Court and seek an early disposal thereof.
Deeply obliged, Your Lordship.
Verse 21 is our arbitration petition, right?
Notice.
Much obliged. Please, Your Lordship, this is an arbitration petition on section 11 seeking appointment of an arbitrator.
We should take the next.
Obliged.
Session of time.
Your Lordship, I appear on behalf of petition number 1.
Well, no time before. Therefore, the reason mentioned here, letter dated 7th for April 2026. 6 months more time is granted to the court concerned to decide trademark suit number 3 of 2019. No
Grateful.
further extension shall be granted. Take no further extension shall be granted.
My lords, this pertains to the elections in the state of my lord.
We have constituted tribunal yesterday. Please go to
I have seen that, my lord, but this petition is against the order of the high-powered election supervisory committee itself.
the election
my lord,
tribunal.
So, my lord, above that, my lord, there is no appellate authority as such. Your lordship, my lord,
The
saying
election has taken place, you are challenging, those very grounds are available to challenge the election.
those grounds are. I'm so grateful to your lordship, my lord. What had happened, my lord, your lordship has seen it, my lord. Rule 10, my lord, is very clear. It provides that only an honorable retired judge of the High Court or a senior advocate has to be appointed as returning officer and observer. And my lord, the secretary of the Bar Council of Maharashtra and Goa was appointed as a returning officer. And what he has done, my lord, he has created a mess of everything. He has created a mess, my lord. What has happened in the voters list? There are many people who have already expired. Bar Council would have records of people who have died. So in the voter list, valid voter list, and this was not kept for objections. And anybody who wants the voter list has to pay 10,000 rupees. So, my lord, all these difficulties are there, my lord. I am only pointing out to your lordship, my lord.
Find no ground to entertain this petition. The same is accordingly dismissed. However, if any individual member of the Maharashtra Bar Council of Maharashtra and Goa has any remains against selection of the elected members, from a liberty is granted them to approach the election tribunals constituted by this court. Wide order that it's also called pursuant to
Please.
Yeah, please, Lords.
Lord, my lord, item number 25, my lords, there are several directions by this honorable court.
What is this?
My lord, despite there being several directions by this honorable court, my lord, what is happening before the Delhi High Court, my lord, may kindly see, my lord. No, my lords, I'm not saying about my choice, my lords. I am saying that this honorable court order may be followed, my lords. There is a judgment of this honorable court. May kindly appreciate, my lord, what has happened. Even, my lord, the...
To entertain this petition without discussion.
Lord, it may be considered that the judgment of this honorable court.
Sorry, if this kind of petition we start entertaining, we will destroy the system.
No, my lord, my lord, not in this matter. There are several matters this is happening, my lord. So, But difficulty is that, my lord, this honorable court judgment is that it should go before the same bench. And it is not happening, my lord. Or else there should be clarity that whatever bench is see, they may hear the matter. Nothing else, my lord.
The matter is not being heard or in delay, please approach the Chief Justice of the High Court. File a judicial side application.
Is governed by the rules of the respective high courts.
I bow down, my lord, but
The roster is fixed by the chief.
my lord, I bow down, my lord, but the difficulty is that this is judgment of this honorable court.
Judgment of the honorable court subject to the rules framed by the high court.
Then, my lord, the matter should remain where it is, my lord. What is happening, it is going transferred.
Justice of the concerned high court.
My lord, then liberty may be granted to the Chief Justice for this thing, my lord, because we pointed out registry several times, my
Justice
lord.
like that. No.
I bow down, my lord, very well. I'm obliged.
Where is Dr. Singh?
Yes, Your Lordship, I'm mentioning item 27, Milord. It's a judicial officer matter, Milord. Kindly list on next Monday, Milord.
Not next Monday, there is no.
Milord, they all are out of service since 2015, Milord. Out of service during the probation, Milord. It's UP matter, Milord. Coming.
There is no such evidence.
May I make one mention, my lord? Item number 26 was shown to be taken up in sequence first.
Two cases and still to continue.
May I make mention, my lord? Item number 26 was earlier shown to be in sequence. Now item number 26, my lord, pertaining to the elections of municipal council where Justice Nirmalji Kaur was appointed.
Patiala Municipal Corporation, there is no urgency in that matter.
Lord, my lord, oath ceremony of the elected members is under stay, my lord. That's the problem. My lord, we are unopposed elected members. Our oath ceremony is, my lord, under stay.
We'll take up after the break.
Lordship can only say, my lord, we can be provided the report of the commission. If Lordship approves it, at least we can have a look at that, my lord.
No, report first we like to see and then.
Lordship has not been able to, sorry, I'm sorry.
Because we have not seen ourselves.
No, it's all right. Then Lordship will,
Yes, Dr. Singh.
immediately after opening, my lord. Grateful.
It is in 31, Manas, in item 31. We've done everything, this bar the shouting, but because of census and SIR, we have shortage of manpower. Your Lordship, last date is 30th June. We want, Manas, a short extension of 90 or 60 days. Money has been allocated in the budget also. But we have,
Item 31, what is item 31?
31 is the
Relates to the
Karnataka date.
elections.
We have to complete the process. Either Lordship will have it on Monday or your Lordship. I know, Manas, I have asked time many times.
15.
Your Lordship, 1 minute, sir. Just
Last election was held in 2015, your lordships gave a categorical deadline. It can't be that a corporation functions for 15 years, 10 years, 12 years without election.
You're holding it. Can we go in a methodical manner?
Lordship, at best, give them 15 days time, not another 3 months. Your lordship, order was
Actually,
categorical.
this matter is giving unnecessary impression of delaying tactics on
That's
the
right.
part of the state.
Can I go in a methodical manner? Either your Lordship is short of time today, have it on Monday, or let me explain right now. Give that note, please. Just give me 2 minutes.
All right, on Monday, please have instructions.
Yes, I've got the note ready. Everything is done. Budgetary allocation is made. But for the manpower problem we have, and that's why we want 2 to 3.
What manpower?
2 months to 3 months. 2 months to
Sir,
3.
the state to come and say it can't hold elections in 1
Can you now hold in 2 months?
No, 30th is your Lordship's time already given June. I want first 3 months. Your Lordship will reduce it by 15, 20 days. And
So I represent the state election.
just give the note now today.
Take into consideration the totality of the circumstances. However, as a last opportunity, 31st August 2020.
I am guilty of that.
It is made clear that no further extension will be granted.
I think your Lordship has been very kind. I don't think we should ask.
State professional, now go and activate your machinery.
the state shouldn't be arguing.
Everybody needs to hear it.
You ask for, Mr. Shetty.
Can I request for September, my lords?
Now we know it that when you ask for 3 months, you knew that you can do in 1 month.
But, on behalf of the election.
Do it, please.
I may request,
Lord,
my lord.
Now please do it.
As far as the election commission is,
My lord.
as far as the election commission is concerned, we have also filed, because earlier we
You
had,
know that those state and election commissions both are requesting. That's why we are granting.
because they don't have the manpower, I have to.
That's why we are granting 1 month to them and 1 month to you.
Our,
Total 2 months.
very good.
Final request.
Both of
Final request, another 15 days more. The reason is that SIR comes.
31st.
Just 15 days more.
1 month, more than 1 month already you have. Please don't appreciate, please, more than 1 month you already have. We are in May.
2 months. I didn't ask beyond 2 months. Let it
Yeah, we are in May.
I think your lordship is extraordinarily kind in this. I think we have to do it within the
There's
time.
another affidavit which has been filed, but your lordship will make it clear. There's one more affidavit filed by the chief commissioner seeking extension up to December. my lords.
No,
That, my lords, because we should not again come back with your lord.
all other praise we have rejected.
Grateful, obliged. With your lord's permission, may I mention item 32 mine? There is a
No mentioning now, no other matter, we are in the part head.
seeking withdrawal of the SLP.
We will give a date, don't worry.
No, he wants to withdraw.
Withdraw.
Withdrawal, my lords.
Item 32.
Yes, my lord.
Oh, well, you should have mentioned the first item in the morning. Good.
My lords, I was patiently waiting for my.
Oh, you are right. You want to avail that statutory remedy. The land counsel for the petitioner state that the petitioner wants to avail the statutory remedy in terms of the High Court judgment.
Yes, my lord.
In terms of the High Court judgment, he may therefore be permitted to withdraw the special petition. Then she ordered accordingly. The petition shall be ordered accordingly.
My lords, the statutory remedy is against the order of the commissioner, my lords, wherein the properties have been attacked.
Statutory remedy in terms of the order passed by the commissioner of police Lucknow.
My lord.
Commissioner of police Lucknow.
Yes, my lord.
In terms of the order passed by the commissioner of police Lucknow, for the petitioner wishes to avail alternative remedy, the special petition is accordingly dismissed as withdrawn with liberty aforementioned.
Yes, my
My lords, item 30 also is only an application for withdrawal. My lords could allow that.
Item 30?
Yes. It was a fresh IA.
Because item 30,
There
there is application for substitution of appellant's name, which is a formal application that may be allowed and the appeal may be allowed to be withdrawn, my lord.
Lords withdrawn.
IA number 1091722-2026 allows the name of the appellant is ordered to be corrected to be read as National Petroleum Construction Company. Instead of National Petroleum, be read as National and be read as NMDC, Energy PJSE. We don't know what is
PJSE, yes.
PJSE in place of National Petroleum Construction Company. Yes, IA number 109-167/2026 as played for allowed. The appeal is dismissed and withdrawn.
I'm so grateful.
Obliged.
State government, item 39 is federal matter is state government who have not followed the Andhra Pradesh model. Post federal benefit to the retiring resident. Some states have followed, others have not.
29.
29 lord.
We understand, bar, the practice at bar to be added.
No, has already done. Now the post federal benefit, they have part of the Andhra Pradesh.
Take the mic, Mr. Sukha.
Well, this is medical reimbursement matters.
But is it not based on the claim that the judges who are elevated from the bar?
Post federal benefits, they should be uniform in all over India.
Medical reimbursement, lord.
We will take up immediate after break.
Very well, lord.
Yes, Dr. Singh.
We are just sorry, we are not making an earnest request again. If an opportunity can be given to conciliate, it's a contentious issue. While these arguments are going on, may not be some opportunity won't.
We have already indicated, please go, we will grant you sufficient time.
Yes, my lord.
We will ourselves will say, no issue. If you can resolve
A matter like this will go a long way with us. Ultimately, the foreign investors
we
want
have
companies.
absolutely no difficulty, but let our
Conciliation should not go on
our job be over, at least because we have not, unfortunately, we have not scheduled any other matter. Yes, Dr. Singh.
May it please you, my lords. My lords had reached the demand notice of 3/11/16 at page 493 of the volume 1. At page 493 of SLP volume. That's where lordships were yesterday. SLP volume 493.
Page 493.
Lordship, please. That's where Lordship stopped yesterday.
Yes.
The government rightly addresses it to three entities in individual and of course collective capacities because they are all claimants, affected persons, etc. Only the first page is enough. Then come to the arbitration notice by me at page, this is an impossible page. It's 2064. PDF is possibly easier, but you're also using hard sets. Probably volume 2 additional documents, I'm told. But it's 2064 in sequence. Keep giving, keep getting. Additional volume 2 maybe. This is the basic document triggering the arbitration. The court masters can open it rather than searching for it, they can just give that. 2064. Yes, notice of arbitration. This one. Same document, which is the right document.
Is it the same notice that it was addressed to three?
No, this is the notice invoking arbitration. That earlier one was from the government.
This is by you.
This is by me invoking arbitration. Perhaps your lordship doesn't have it, but the other two lordships don't have it. It's the same volume, it's the right volume with the Chief Justice. Only one para at 2065.
Para?
Well, that starts at 2064. Next page 2065. One para 2.
RIL, BP, and NICO.
So all three names are given. Hold participating. May I read it slowly for my lord? My other two lords don't have it. RIL, BP, and NICO hold participating interests in block so and so at 60, 30, and 10% respectively, and together constitute the contractor as defined in the PSC. RIL provides this notice in its capacity as operator under the PSC for and on behalf of all the constituents of the contractor. But this is a little important for me. The Honorable Chief Justice has flagged it, but it may kindly be flagged and given to my other learned judges first. Because this is directly, this is the foundation of the trigger. I make it clear. Barring a stray objection by Mr. Ganguly in the procedural order, this goes along merrily, somebody pulls the rug under my carpet later on, as if we are only one Indian. So this may be flagged as a very important document. Then they have still not found it. It's the same document which Chief Justice has. The same justice. Your Lordship has got it. Then 11.11.16 is the next document, which is additional document. Yesterday, my Lord used this file. Yesterday's file. At page 8. You already used it yesterday. Yeah, this is what happens when you don't give a single information. No, you used it yesterday.
Page 8, Annexure 8.
Yes, correct.
11th November 2016.
Correct, absolutely correct. This, my Lord Justice Bachi also used the same volume yesterday. My Lord Justice, they've got 11th November 18. Now, this is by BP Exploration Alpha. We joined, as a Lordship knows, in 2011, part of the collectivity. So this is 11th November from BP, the third constituent.
Yes, on the right hand side on the top. it is.
Addressed to the government in the matter of an arbitration under so and so between Reliance Industries as operator, as claimants and the government of India. Para 2 is very important. We write on behalf of BP, etc., to confirm that the notice of arbitration was filed by RIL in its capacity as operator for and on behalf of all constituents of the contractor. Then, Malas, the next page, the very next page, is the other constituent, Nico. Date is the same, para is the same, addressed to the government. Para 2 is the same. Now, my lords, will come to the statement of claim by me. The statement of claim starts in the SLP volume, or it's a continuous thing, 2128. 2128 in the main volume continuation. 2128.
Next one. 127.
This is a volume 2 of the SLP continuation. Volume 2. 2128. Two one two eight. This is again a foundational document called the Statement of Claim. My lord has got it?
No, just point out what is the description of the document.
2128 it starts. Come to 2131 of that page, where I have described the parties in the footnote and clarified that I am an operator acting for all. Well, these are a little important. I don't know why they're not. Because there are 18 volumes, basically 1 and 2 volumes are only being used, and the additional volume. So
2131.
it starts at 2128.
That's it.
This is a foundational document, statement of claim. At Wallace 2131.
That's it.
At the bottom footnote, small 3. Footnote at the bottom of the page, Chief Justice has got the volume. Reliance acts as operator for the block, and it provides this statement of claim in its capacity as operator under the PSC for and on behalf of all constituents of the contractor. Wherever the context so requires, reference to Reliance is to be construed to be a reference to contractor. Then in sequence comes the hearing on 2nd March 2017. So this last document was 31/3/17. The last one your lordship saw. That's the statement of claim.
Page?
No, what you've seen already. 31/3 was 2017 was the date. Now there is a hearing, a procedural hearing. The transcript is at page 2085. 2085. Same volume 2, my lord justice. No, but this is the same part. Yeah, what to do then?
2085.
Yes. So if our lord see in the middle, the names of the chairperson and the arbitrators are given. Then below that is given procedural hearing March 2, 2017. Right, Manas? Now your lordship will go to page 2087.
2087, yes.
Now on the left side, page 6, chairman, about middle of the page, left quadrant, the box. Chairman, the second question I have, and this is for the claimant, is that we understand the claim was commenced by Reliance on behalf of NICO as well as BP. So can I assume that the only named parties will be Reliance and not NICO and BP? Mr. Sprange. Sprange is our lawyer. Not sure you got that? Mr. Sprange answers, that's correct. Reliance brings this arbitration as operator as defined in the PSC, and the other constituent parts of the contractor are BP and NICO, although Reliance is the only named party. And I think you will have seen the representations from NICO and BP in their bundle as to their position. Those letters by NICO and BP said, we are fully endorsing this. We are there as claimant, but he's our representative. He's doing it. Then, Malaz, there is another hearing transcript at 3722. So this hearing, the one I just finished reading, is 2nd of March 2017. 2nd of March 2017. The next date is 31st of January 2018 at page 3722. But they're not using PDF pages. I see. Your Lordship's computer is using PDF pages, so I can call out the PDF. That will be very much faster.
Yes, that's.
Can I do that? That will be very fast. So now the next date is 31/1/18, which is PDF page 4759. That will come instantly to your Lordship's screen.
No, it's not matching, sir.
Hmm?
It's not matching.
So then whose fault is that? Then why do you say that? No, but PDF is not matching. Why do you say this? Let's come to 3722. Mr. Can you pull up on your computer will be faster. If you pull up 3722 on the right side, type page. That's easier. 3722. Don't call out things without thinking first. Not matching so to speed. 3722. Yes. Now, sir, I would like to deal briefly with the construction of Article 26. I hope BP's very short submissions will be of some assistance to the tribunal. But they're all there as parties. They just allow Reliance to take some lead. That's all right. They have a man speaking for them. In circumstances where there has been considerable focus on this provision, and now it relates to the non-operator parties specifically. So the operator is Reliance, the other non-operator party, but they're all contractors. They're all contractors. As you will appreciate, the next para, the Honorable Chief Justice got it. As you will appreciate, BP has considerable experience of good international petroleum industry practice on provisions not dissimilar to Article 26, which occur in many PSCs around the world. And that understanding comes from its role both as operator and non-operator. Now, they go on and give slides. I'm not reading it. They explain, because they have reputed people in international petroleum practices. They give slide after slide, which goes on for 2 or 3 pages, which I will not trouble your Lordships. It continues with submissions by Mr. Carroll appearing on behalf of BP till 3727. Almost 5-7 pages, where the chairman thanks. Now here, I must show the passing objection of Mr. Ganguly, in fairness, appearing for them. So, just notes, from the page your Lordship started till page 3727, BP makes 5 or 7 pages of submissions, which are on the merits your Lordship need not read. But BP's counsel, Carroll, is making arguments at the invitation of the chairman. I hope I'm clear. At the end, just come to 3727, where the chairman says, thank you, Mr. Thank you, Mr. Ganguly, your time. Closing submissions by Mr. Ganguly, that's the other side. I don't think I should take any cognizance of what has been told to you on behalf of BP for two reasons. BP has chosen to be represented through the council who has already addressed you sufficiently enough time and material have been placed before them, and that's enough. So that's a duplication argument. Lordship says, well, sometimes I have argued everything, why are you repeating? That's all right. That doesn't mean become an international arbitration, become domestic arbitration. Your Lordship is saying don't waste double time. Secondly, they seem to advocate the cause of NICO. NICO has not come forward to say something. I don't think that there is any credence could be given to this kind of submission. Thirdly, the submission proceeds to almost lead evidence on facts as to the purpose for which NICO's report, the DM report, was prepared and produced. You need someone to come on or before the tribunal. NICO was the best person to come and tell you, but they have chosen not to come. They have remained present, but not to state a case before you. BP can't look at what purpose for which NICO allegedly obtained the copy of that report. Now, this can be evidentiary value. Your Lordship will reject it, etc. It doesn't mean that NICO and BP are to be erased from the parties to the claimants. And the matter becomes from international to domestic arbitration. Next para. It is preposterous and ridiculous for BP to suggest that the government should have called for this report. It's begging the question. So all this is on merits first. The question is, if the report was in existence, it was admitted, the report, etc., etc. This is now on the merits. I can read, but there's no need to read once. The short point is that treating it as a purely Indian party is not a fair assessment. There are two other parties making submissions. The next page is PDF 4795, normal printed page 3758. 3758. Where counsel for NICO appears, Mr. Shashi Prabhu, who's here in court now today. 3758. And after this, I come to the award straight away after this. Does my Lord have 3758 on the screen? Your Lordship has. In the middle of the page, Shashi Prabhu, I have one statement to make. Formality only, because there was a statement that NICO's case is not set up by anyone. That is not correct. So he's disputing Mr. Ganguly's understanding. In the beginning opening day, I said that Salve is speaking for NICO too. I accept Salve's full submissions as NICO's. Now, this is something which anybody had anticipated, whether they have to come with guns blazing and say, look, I'm also there. This will happen every day in court. Doesn't change the character. A jurisdictional question of the understanding of 2F and 2H will not change by this kind of conduct. Now come to the award. The award is in the main first volume of the SLP. The normal page is 504 and the PDF is 542. Page 504 in the first SLP volume. We are now on the award model. SLP volume, not additional documents volume, SLP volume. I'm going in sequence. Okay, you've got my notes. Tell me sequence. If there's something in between, tell me before I go out of sequence. May I read, Bills?
Yes, please. 506 it starts.
Yes.
Whatever allowed party wants.
Justice Bakshi, Justice eventually happy. 513, para 8. 513, para 8. References hereafter to the contractors or the contractor shall mean RIL, BP and NICO. Lord has got it?
Yes, sir.
Then, Wallace, page 569. 569. The people appearing are Mr. Ben Carroll of Linklaters for BP, Mr. Shashi Prabhu, RS Prabhu and Company on behalf of NICO. Then there are other people on NICO also, etc., etc. Then come to 574. para is 4040. May I read 574 minutes?
Yes,
The claimant has in its statement of claim, that is our side, sought the following, declaring that the contractor has produced all hydrocarbons from its contract area by conducting petroleum operations reviewed and approved by GOI. Declaring that the contractor, they're all, contractor means all of us, fellas, has the right, not operator, the word is not operator, the word is not operator, has the right to produce all hydrocarbons from wells drilled in its contract area by conducting petroleum operations reviewed and approved. Declaring that the contractor, not operator, fellas, is entitled to retain all benefits. Fourth one, declaring that the contractor has paid Government of India both profit, petroleum and royalty, etc. And then going on, next page, point 6, is also declaring the contractor apart from the Government of India, etc. Now your lordship will come to 674. May I read from one page before, Malas? 673. Whatever is there, lordship, I will see it at one go. 157 does my lord have para number? Para is 157, page is 673.
Yeah.
In considering these submissions, we fully accept and recognize that the named claimant in this arbitration is RIL and that NICO is not formally a party to this arbitration. This can be read out of context, but I'm reading it as it is. For present purposes, we accept the evidence of the claimant's witnesses that RIL did not itself receive a copy of the report of 2003 until May 16, that's our case first, and copies of the 2004 and 5 reports until after the commencement of the present arbitration proceedings. It was vigorously submitted on behalf of respondent that at the very least, the claimant must have had knowledge of the 2003 report time issued or shortly thereafter. In that context, the respondent relied heavily on a letter from DGH to Mr. Ganguly, dated so-and-so, and the reply dated so-and-so. Next page, was. On this basis, it was submitted on behalf of the respondent, Mr. Ganguly's suggestion that RIL did not know about the 2003 was simply untrue. It is sufficient to say that we do not accept that submission. Now come to the real parameters on this issue. We are on the parties issue, party to an agreement. In any event, the foregoing conclusion is not of itself fatal to the substantive argument advanced by the respondent. This is very important. In particular, it is in our view important to note that NICO is itself a party to the PSC. It's a party-centric approach I am advocating. By virtue of articles 1.27 and 1.21, which I showed yesterday, the term contractor is in effect defined to include both RIL and NICO collectively and later BP also. As such, where the PSC imposes an obligation on the contractor, as it does, for example, in 26, no relevant distinction is to be drawn between RIL and NICO. In effect, they are to be treated as a single unit. This conclusion accords with the overall structure of the PSC as well as the commercial reality. Therefore, as well as the commercial reality is very important for us. Therefore, we accept the submission on behalf of respondent that at least for present purposes, the acts and omissions of NICO would bind all other constituents of the contractor of block. So all are there with us. It is not that some are not there. Page 675. Therefore, we accept the submission on behalf of the respondent that at least for present purposes, the acts and omissions of NICO would bind all other constituents of the contractor of block so-and-so. It follows that it matters not that RIL did not itself see or was not itself in possession of the NICO reports until relatively recent. So they say they're all together, it binds. Later on, they say that the binding will have no effect because all the receipts go to the Government of India, the same owner. So it's an irrelevant point. Let's go further. Before turning to consider the substantive issues concerning the alleged breaches, this follows is the other point. You should leave this. This is not relevant now. We are on the party point. Now, one part happens in this award because brothers, they did not actively argue. I showed the two portions where they had a lawyer and they argued. So at the end of the arbitration costs were claimed for both Mr. Sashi Prabhu and his team and for that Carol person. That is denied by the arbitral panel as arbitration costs. Saying actively Mr. Salve is arguing for Reliance. He is the operator. And you may be parties, but these costs need not be given. That is used in the impugned order to say you are not parties at all. Now see that part in the award first. 718, para 192. Will such things alter the character of an international commercial arbitration to a domestic arbitration is a fundamental jurisdictional question. My lords will ultimately decide something which will be law. That because costs were disallowed for an arbitration, because they hardly had any presence to argue because somebody else was arguing for them. Therefore, that for them argument still means a domestic arbitration because that RIL is an Indian company. Page 718. Para 192. Well, the jurisdictional questions can't be decided on such basis. This is one of the major bases of the impugned order. Reversing two concurrent orders. The impugned order 37 reverses two concurrent findings principally on this point. There is no dispute that the claimant is required under the contract to lead the contractor party under the PSC. Its interest and those of BP and NICO were aligned vis-a-vis the respondent and they had consistently so acted. Now this is enough for the question which I am arguing. I am not concerned about costs. Your Lordship allows this is enough for the question I am arguing. However, not being a party to the arbitration, should the costs incurred by each of them be included as those incurred by the claimant and recoverable from the respondent? In the tribunal's view, this should not be. The scheme of the PSC is such that the claimant as operator is the only party in the PSC. In the PSC, entitled to deal with the respondent. Because it's like saying, well, three of us are claimants, I nominate my learned friend Mr. Parikh here to deal with them. That's what it really means in substance. In the tribunal's view, this should not be. The scheme of the PSC is such that the claimant as operator is the only party entitled to deal. Neither BP nor NICO had sought to join as a party. Now, these are the loose paras picked up by the division benches. The respondent had throughout these proceedings maintained that BP and NICO had no right to be heard subsequently. The costs in these foreign arbitration, the international arbitration are given the basis of hearing and the right to be heard. And they rightly said that Mr. Salve argued for Reliance, others did not argue. That's how they gave up. Had maintained that NICO and BP had no right to be heard subsequently, although the tribunal on occasions permitted them to make certain statements. Whatever the costs incurred by BP, if not recovered by the party, should not be permitted to be recovered through the conduct of the claimant. Now, what is substance I would request my laws to go to, not the form, and nitpick on words. The substance, in my understanding, and I may be wrong, that is that you have three claimants. One was an operator, you chose to act through him. We can't give you costs for the others who hardly argued except briefly. That's all that it means. Now let us come to learn it single judge verse in the 34. That is verse at page 3773. 3773. What are you saying? What are you saying? This one. Oh, I'm sorry. No, I'm sorry, Valis. Before that, at 3773, my lord will see the parties. Before we come to the single judge, the parties are important. So, Valis, they lost the award. My lord, the other side lost the award. This is important. I'm sorry, your lordship has to go to another volume. So, they filed a 34. In the 34, they made these parties just before coming to learn single judge. See the parties at 3773 in their 34. Does my lord have 3773? What is the next number? The PDF, if it is nearby matching, is 4810.
It's on the screen.
PDF is 4810. You can adjust the pages. So, Union of India versus Reliance versus British Petroleum versus NICO. That's all I'm showing. These are three parties made not by me but by them. Now come to the single judge. On this. Yes, that's right. This is at page 900, printed P4. In the main SLP volume. 900. With respect, I submit that unless you find a perversity in the learned single judge, after a reasoned award, 37 certainly, despite an error which you might think is an error, you meaning not your lordship, but 37 court, cannot lead to an interference. So see how the learned single judge discusses this. It starts at 938. Sorry, 900. PDF is 938. Normal is 900. It's very important, the first page verse. Does my lord have it? 900. First volume. Basic SLP volume. No, you got the wrong volume. Not the second volume, sir. Put the main volume. SLP volume. On the screen. No, this is the other. May I start? My lord has got page 900 of the main SLP volume. Main SLP volume, page 900. Where lordship read the award just now. Same volume. May I start from 900? Sometimes the computer is slower than the manual. This is one such time. What is the problem? It's an SLP volume. SLP volume my lord has got. So the 900 is the page of the High Court order starting. This 34 order, Justice Baki may be not having it. Yes, Justice Anup Ambani's judgment. Yes. All three have it, please. Now, the top page is important. Mr. Venugopal led for the Government of India in a 34. But see below, Mr. Salve argued for RIL, Dayan Krishnan argued for BP, and Mr. Shashi Prabhu argued for NICO. Three parties, three council, three sets of parties. Then come to page 902. Yes. Where there is an opening paragraph that can be ignored, but that's a summary. The opening paragraph. Then come to para 23 at page 932. Yes.
Yeah.
My lord has got para 23.
23.2 you want to have.
But no, I want to read a little bit more. To make good its submission that the arbitral award arose from an international commercial arbitration, learned senior counsel submits. The PSC from which the disputes that were referred to arbitration is a commercial contract entered into between both Indian and foreign entities. The demand notice pursuant to which the arbitral proceedings commenced was issued by the ministry to all three entities, namely Reliance, NICO and British Petroleum, collectively defined. Next page, page 933. The notice of arbitration was served upon the ministry in the latter's capacity as operator under PSC and was supported by separate letters from NICO and British. The findings of the arbitral tribunal have determined the rights and liabilities equally of all constituents of the contractor as defined in the PSC. To support his submission, learned senior counsel has also drawn the attention of this court to decisions of the Supreme Court in which, when one or more parties to the arbitration agreement were not Indian, the arbitration was held to be an international commercial arbitration. The section yesterday I read was at least one. At least one. Attention has also been drawn to a decision of the coordinate bench of this court, that is Delhi High Court, wherein a challenge under 34, considering that one of the parties to the agreement was a foreign incorporated entity, the arbitration was found to be an international commercial arbitration. Therefore, the award could not be assessed on the touchstone of patent illegality. It is argued if any doubt were to remain. Now, this is very important. This is the next point I'll come after I finish the letter in the judgment. This is very important. Just tick it. This judgment I'll be coming. This is the direct inter partes issue estoppel res judicata judgment for this. It is argued in its decision in Reliance versus this judgment is 2014 11 SCC at the bottom. I'll be coming immediately after this letter signature to that judgment. While dealing with a dispute which arose from the same PSE, that is subject matter of the present proceedings, the Supreme Court has held that even though Reliance acted as operator under PSC for and on behalf of itself, NICO, and British Petroleum, which are all three defined as contractor, NICO and British Petroleum were very much part of the legal relationship from which the disputes arose. And since this is well decided by the Supreme Court, inter parties on the same contract.
Page 945, it has been dealt with in detail.
I'm grateful. But there's a little bit here that I will come into that judgment, because that judgment, and one of the recent judgment of the Lordships following that judgment saying this has to bind inter parties. I'll be coming to this in sequence first. Now come to verse 9. Page 945. Para 34. Now, whereas if your lordship has said 100 times, I may write it differently, your lordship may think a little differently, but your lordship finds something very strangely perverse about it, then your lordship interferes. Not because the lordship could have done it differently. So perfectly valid judgment, very reasonably written verse, taking into account everything. That's why para 34 verse. Para 34. In the opinion of this court, Reliance's argument that the arbitral proceedings were an international commercial arbitration within the meaning of 2(1)(f, and as a consequence the ground of patent illegality is not available, has merit. As pointed out, both Reliance as well as NICO were signatories to the PSC. I am repeating, was party-centric, agreement-centric, contract-centric and party-centric, not dispute-centric. The demand raised by the ministry Viday's letter of 3rd of November, Lordship has seen that, which led to invocation, was issued to each of the three constituents. The notice invoking arbitration was issued by Reliance on behalf of itself, British Petroleum and NICO, which entities held a participating interest of 60%, 10% and 30% and 10% respectively. And the impugned arbitral award determines the interest not just of Reliance, but also British Petroleum and NICO. Furthermore, as correctly pointed out on behalf of Reliance, the decision of the Supreme Court in Reliance versus also, arising from the very same PSE, the same date, same document, 12th of April, closes that issue. In that case, the exact same parties, three names are given, Reliance, NICO and BP, on the one hand, and the Ministry of Petroleum on the other, were parties to the disputes arising from the same. In that backdrop, the Supreme Court held as under. But this I will read separately, so just leave it for a minute. Just see the last underlined portion though, on the same. Not possible to accept the submission of Mr. Diwan, perhaps the other Mr. Diwan, right? That the arbitration in the present case is not an international arbitration. So my learned friend is now on the right side.
There is no stopple on this side.
It is equally not possible. I come to the underlined portion, only the bottom. I'll be reading it. Where RIL acts under PSC, including by commencing arbitration, it does so not only on behalf of itself. Next page, 947 top. Where RIL acts under PSC, including by commencing arbitration, it does so not only on behalf of itself, but also on behalf of all constituents of the contractors, including NICO and BP. Your Lordship has held this in another case, not this case. And that's to be ignored. Between the same parties, the same PSC. I am inclined to accept the submission of Mr. Salve that there is a significant and broad-ranging dispute between RIL, NICO and BP on the one hand, and the Union of India on the other, that goes to the heart of the main contractual rights and obligations under PSC. Furthermore, it is etc. Contradicting Reliance's submission, I'm reading what is para 36. 36 is important. The other side, the Union of India. Ministry relies upon the decision of associated contractors to argue that the decision of the Supreme Court in RIL holding the arbitration in case to be an international commercial was merely an administrative order and is not a binding precedent. Incidentally, now, Malas, fortunately, your Lordship has clarified that at least without going into all it may be or may not be. According to me, that's too much for us saying it now. But pre-amendment, because we are considering pre-amendment, assuming that it is an administrative order where it is inter parties, there is complete estoppel and res judicata. Your Lordship Supreme Court has held that, which I'll be eminent colonizer reading shortly. This contention, however, is misplaced, since in RIL, now the learned judge is saying this. This contention is, however, misplaced. So, learned single judge is repelling the contention of the present respondents. This contention is misplaced, since in RIL versus Union of India, in relation to dispute between the exact same parties arising from the self-same PSC, where the arbitral proceedings were carried on by Reliance in its capacity as operator on behalf of the other two constituents, the Supreme Court has taken the view that the arbitral proceedings amounted to an international commercial arbitration. In the opinion of this court, the disputes that were subject matter of arbitration in the present case also relate back to the main contractual rights of all the parties under the PSC. It matters not whether this view was taken in administrative order or in a judicial decision. The court is in respectful agreement with the view taken. As a result, page 948, this court holds that arbitral proceedings in the present case amounted to an international commercial arbitration. Therefore, the scope of interference under 34 is even narrower, and the grounds of challenge canvassed by the ministry that the arbitral award proceeds on ignoring evidence on record or draws inferences with no evidence is not tenable in a challenge to the arbitral award, since those would fall in the ambit of patent illegality. That's what is the case. Now, let us kindly come, before I come to division bench, see these two judgments first for us. RIL, which, well, most of these cases I'll not be reading, but I put them all together. Most of these I won't be reading. Please come to Malas in this volume. Please, 298. Cannot change it like this. Open it. Why did you change the pages again? Yes, 290. A little wrong, but come to my pages are correct. 298. Your index is wrong. 298 of this volume. Yeah, you either make the index wrong or you make the numbering wrong. What's the point of it? 298. The unamended 11. Both RIL 2014 judgment and today's case. That's an important point to note. My lord has got that. It's 298. This judgment is on the unamended law by Justice Nijar, and our today's case is also under the unamended law. So para 2, so on the top, same parties on the top. Now come to para 2, which is at page 305. Petitioner is a company incorporated and registered under the provision of the Companies Act. Petitioner 2 is the same, no? Petitioner 2 is a company incorporated in Cayman Islands, British Virgin Islands. Petitioner 3 is a company incorporated in the laws of England and Wales. The respondent herein is the Union of India, referred to by the Joint Secretary, Ministry of Petroleum. Now come to 3. Briefly stated, the relevant facts are as under. In 1999, the Government of India announced a policy, new exploration and licensing policy. Under any LP, certain blocks of hydrocarbon were offered for exploration, development and production. One of the said blocks was KG, same case, same block, same contract, same parties. The joint bid made by the petitioners 1 and 2 for block was accepted by Government of India. Thereafter, on 12th of April, same Mellors contract, my lord saw. Production sharing contract, that is PSC, This case is when I asked him, why did you say this? I said, no. Yes. On 12th of April, production sharing was entered into. The arbitration agreement in PSC is contained in Article 32. Doesn't make any difference. Just check the dates. Check the dates. The dates. Para 5. Just check the dates, please. You are just passed through all this. Somebody said pass through that was on 8th of Para 5, on 8th of August, the Union of India granted its approval to Petitioner 1 to assign 30% of its participating interest. Check A is it after, B doesn't make any difference. What will answer? On the same date, on 8th of August, Petitioner 3 also entered into as a party. Further, Petitioner 1 was appointed as the operator of Block KG6, both under terms of PSC and the joint agreement. Then Malus Para 9. So operator is there, Malus, in Para 5. Now come to 9. Same operator, same contract. The respondent, however, by a letter, called upon the petitioner to withdraw the notice of arbitration on the ground that the same was premature, for the reason that no dispute existed. It is noteworthy that no objection was taken in regard to petitioner 1 being the only party under the PSC that seems to be raising the dispute. This is very important, Lordship doesn't mind underlining. The learned judge notes the bottom of 307. When the dispute was sought to be said to be premature, the government said, no dispute arises. Then the judge adds, it is noteworthy that no objection was taken with regard to petitioner 1, that is me, being the only party under PSC that seems to be raising the dispute. Then Para 21 at page 311. Para 21 at 311. Well, there would be a travesty if the same finding between parties in a 11 proceeding are to be ignored so casually on the ground of administrative order. Everything is the same. So one of the same agreement leads to two disputes. One is the current one is the earlier one. One is the international commercial arbitration, the other is not international commercial arbitration. Can your lordships countenance such kind of a consequence for us? Same contract, same parties, first dispute leads to one finding, it's international. Now your lordship will treat this as a domestic arbitration. Para 21. My lord has got that. Para 21. International commercial arbitration. It was submitted that the present arbitral proceedings relate to an international commercial arbitration as defined under 21F. The learned senior counsel pointed out that 2 of the 4 parties to the arbitration are based outside India. Petitioner 2 being a UK-based company and Petitioner 3 being based in Canada. Substantiating this submission, it was pointed out by Mr. Salve that each of the petitioners is a party to PSC as defined under 28.1 and each of the petitioners comprises a contractor under Article 2. Para 22. It was also submitted that petitioner 1 as operator performs each and every function of the contractor under PSC on behalf of all the constituents of the contractor as defined under 7.1 and 7.3. Lordship saw that. Mr. So-and-so mentioned that the Appendix C provides accounting procedure which is required to be followed by the contractor and the government. Then its senior counsel also brought to our attention the accounting procedure that is required to be followed by the contractor and the government. Sections 1.42 and 1.44 of C indicate that the accounts are to be maintained by the operator on behalf of the contractors. Well, it's crystal clear. On the basis of the aforesaid, it was submitted that for the purpose of cost recovery, only one set of accounts as opposed to 3 sets of accounts has to be maintained. Thus, according to the submission, the award will affect the cost recovery under PSC and impact all the parties. But the award will not affect all 3. With greatest respect, I ask myself that question. Obviously, well, it will, particularly the petitioners equally. In the light of the aforesaid, it was submitted the operator was therefore obliged to raise a dispute on behalf of all the parties. This is also made clear in number 8. Lastly, it is submitted that the respondent itself has always understood and accepted that the substance of the dispute is related to and has implications for all the parties. It was also pointed out the notice of 2nd of May was addressed by the union to all the 3 petitioners and that the nomination of the arbitrator was with reference to the notice. Similar notice in the present case, today's case, I've read those notices. Then come to para 24. Mr. Salve submitted that the parties cannot confer jurisdiction on the Supreme Court. It flows from the fact that there is an international arbitration. He submits that the stand of the government of India is inconsistent. On the one hand, it is accepted that this court has jurisdiction to entertain the petition. On the other hand, it questions the assertion that this petition concerns the international. Well, how does the Lordship Supreme Court come in under 11.6? You can't say Supreme Court has jurisdiction. Don't go to the High Court, but it's a domestic arbitration. It is further submitted that AP 8 was filed in 2012 on the premise that the arbitration between the petitioner and the Union of India was an international arbitration on account of the fact that petitioner is a company incorporated outside India. It was pointed out that no dispute as to the maintainability was raised at that time. AP 8 was disposed of by this court on merits and not for want of, this is a third proceeding. AP 8 earlier was arbitration petition earlier. No dispute was raised to the effect that this court has no jurisdiction to entertain the petition, which was filed under 11.6. On the basis of the above, he submits that the objection was raised by the respondents that P1 is the only party raising disputes, etc., etc. Now let's come to para 26. Further, it was stated that the joint operating agreement entities, the operator, entitles the operator to initiate litigation on behalf of all the parties. It was also submitted as significant to note that there is inconsistency in the stand of the respondent. On the one hand, the joint operating agreement is also considered here by the learned judge. On the other hand, the respondent claims that the arbitral award would bind not merely 1 but also 2 and 3. However, on the other hand, he insists that they are only between 1 and 3. Well, these are all very important points in this. If the Government of India today is correct, then anything your Lordship decides will not bind NICO and BP, which is not their case. They say no, it must bind. This stand has been submitted to be contrary to the established jurisprudence and arbitral award is binding only on the parties. Well, it's completely contradictory. The whole point is, with great respect, your object is to bring it in patent illegality. So you take any argument which comes for that. Contradictory arguments you are taking. Now come to para 54 at 320. The idea can't be that I stretch the law so that I have patent illegality as a weapon. Look at the consequences of your Lordship's judgments would have a law like this. 54. At page 320. It is also not possible to accept the submission of Mr. Anil Diwan that NICO and BP are not operators under PSC and therefore have forfeited any right to operations under PSC. That's what para 54 was.
Yes, yes.
It is also not possible to accept the submission that NICO and BP are not parties to the dispute. I am of the considered opinion that the provisions of PSC clearly identified the parties to PSC. The disputes that have arisen between the parties are also clearly identified in the correspondence exchange between the parties. The three named contractors are, in fact, frequently mentioned in the correspondence between the parties. It's been correctly highlighted by Mr. Salve. The terms of PSC have to be considered in the light of the fact that the respondent expressly consented after detailed inquiry to the assignment of participation interests in PSC to PP. It is a matter of record that NICO has been a party to PSC from the beginning. Therefore, at least at this stage, it would not be possible to accept the submission that BP and NICO are not operating under PSC. I am also unable to accept the submission of Mr. Diwan that given the nature of operations under PSC, the issues involved thereunder are of public law and public policy. Then, I will skip that and come to 56. 56 is important. In my opinion, the submission is misconceived and proceeds on a misunderstanding of PSC. RIL, NICO and BP are all parties to PSC. They are all contractors under PSC. PSC recognizes that the operator, as opposed to the contractor, would act on behalf of the contractor. All investments are funded not just by petitioner one, that is me, that is Reliance, but also by the other parties, that is NICO and BP. And they are equally entitled to the costs recovered and the profits earned. For the sake of operational efficiency, the operator, not the contractor, acts for on behalf of the other parties. Therefore, I find substance in the submission that the disputes have been raised in the correspondence addressed by P1, not just on its own behalf, but on behalf of all the parties. During the course of his submission, Mr. Anil Diwan had in fact submitted that NICO and BP will be affected by the arbitral award and it will be binding upon them too. This is Mr. Diwan's submission for the government. They will be affected and they will be binding. Therefore, if petitioner 1 was to succeed, the award would endure not only to the benefit of P1, but to all the parties of PSC. Conversely, if the government of India were to succeed before the tribunal, again the award would have to be enforced against all the parties. In other words, each of the contractors would have to perform the obligations cast upon them. In that view of the matter, not possible to accept the submission of Mr. Diwan that the arbitration in the present case is not an international arbitration. May I read one last paragraph before Lordship is rising? Last paragraph. 57. The consequence has to be that if it is not parties, then the award doesn't bind.
Mr.
It is equally, last paragraph, I'm sorry.
Dr. Singh,
I'm sorry.
bit 3 is the arbitration clause.
Yes.
Right. It speaks of two parties.
No, addendum later. It's 2011.
Two parties.
In
Two
2000.
parties. If you see, the tribunal comprises of one arbitrator per party.
Yes.
And the third arbitrator,
Yes.
like an umpire by the two arbitrators.
Yes.
It does not speak of more than two parties in the arbitration clause.
May I answer?
And
Answer
if
is
we
this.
read the arbitration clause as a separate agreement embedded in the contract.
Let me answer straight away.
Will it be a bilateral agreement?
No, straight away. No, not at all.
It will be
Just take 1 minute. I'll just take 1 minute as the Lordship is rising.
So,
the question and read paragraph 57, 2 minutes. The answer to your Lordship's question is simply this. There are two sides which the arbitration clause is defining. That's my answer to my Lords.
the word used is party.
Yes, I'm telling you, Lordship. Party means parties on one side, party oblique parties. There can be multi-parties, whether in any contract, but all their interests are on one side.
Then it will be comprising of multiple arbitrators.
No, with respect. The clause can say
the arbitration tribunal constituted is one arbitrator.
Can I answer?
Of one party and the second arbitrator.
Can I answer?
So it is understood
yes,
that the contractor / contractors are one party.
Yes.
And the government of India is the other party.
Yes, I use the word side. I use the word side for clarity. Side.
And here the party.
One side party will nominate one.
Is the operator.
Can I? There are innumerable contracts. It happens all the time. There is one party which is clear, is the government of India. The contract defines three terms.
This issue has not been addressed in justice.
Whatever they raised would be addressed, but they have not raised it from this point of view. But I'm answering it's an obvious answer, but straight away. It may not have been that.
What I'm saying is we understand your contention that the police as one party.
Not even that. If you just allow me. Not even that. There are innumerable contracts which have A, the government of India. It is very clear it's a sovereign, self-contained party. B, the operators, which have no fight, no difference of opinion amongst them. So there are three claimants with three interests, 30%, 10% and 60%. But they are all parties on one side. Let's use the word sideways. So there are two sides. Now, if a difference arises, a dispute arises, the two sides will appoint one each. And the one each will appoint the chairman. It is not contemplating in this clause that I am also appointing an arbitrator for a dispute interest between us. That is a hypothetical question. Lordship is not dealing with it.
But despite this,
I asked that question.
Yes. No, that hypothetical case will arise. Your Lordship will have a problem.
There.
Fortunately, your Lordship will have problems here without going to the hypothetical case.
Why? This is a very vital issue which you are addressing with regard to the
So I will
fact
show
that
after lunch.
illegality can be a touchstone for testing
I
the
will
award.
show after lunch, Maras, that there are two clauses. One is the arbitration clause my Lord has seen, which is one side versus their side.
Otherwise,
The other is the joint operating agreement. That is our inter se problem. Joint operating agreement, which I showed your Lordship yesterday, is our inter se problem.
it's a different situation. Joint operating agreement actually is not coming into question.
that is intra-party.
Intra-party. We are seeing a dispute arising out of the PSC.
Yes.
And the PSC admittedly is
sides
between four parties.
But it's two sides.
Four parties, three contractors, policing as a contractor,
One side.
speaking through an operator, and the union of India.
Yes.
That is the
That's the correct formulation. Great respect.
subject contract.
That's the correct formulation.
So the parties to the contract or matrix contract